in the strong room or whatever, and I was unable to proceed beyond a certain point unless I read the file. This afternoon I was hoping to see the file before we started, but your Lordship had a closed session, and so here we are. Now, the reason why this is important is that I was able to come across an affidavit filed by my learned friend on behalf of the second objector, sworn on the 11th of November 2022, which at paragraph 8, yes, here it is. Paragraph 8 reads, just turn it. Paragraph 8, it states that the will before the court is a forgery by the petitioners and their advocates in question. This being a very serious allegation, I'll be presenting evidence in support of this allegation at the appropriate time when I'll be seeking to nullify the said will. My Lord, I did ask my colleagues when that challenge was going to be mounted, and I am reliably informed that it is being worked on. An application to that effect shall be filed, as a consequence of which I think that will be done by my learned friend for the second objector, as a consequence of which we, on behalf, I think he, Mr. Morara, and we will join hands in an application where we will be seeking that the firm of Coulson and Honey, or Coulson Honey, ought not to appear in these proceedings for any litigant, because they will be key witnesses in establishing whether or not this will is indeed a forgery or not. I am, from where I sit as counsel, I do confirm that I have had a look at the will dated 23rd December 2016, or the purported will dated 23rd December 2016. It is signed only on one page, or I would not say it is signed. The name of the deceased is written on page 6 of that document in what I'm not sure can be described as a signature. All other pages have no signature or attesting witnesses having signed. So just on that, I would say therefore that perhaps this is the point when, if time permits, those applications will be filed, and then the court can give directions on all applications and determine whether we just go straight to viva voce and deal with everything once and for all. So that's all.
How many applications are pending?
Substantive application, insofar as the DNA application was concerned. There's also another application that sought for material disclosure of information vis-a-vis the will that had been filed. And those are the two applications that are pending.
So for the first and second...
for the second petitioner,
Yes.
Minister Mugumu.
For second petition.
For second petitioner.
Do you have any applications which are pending apart from
Yes.
the release of the direction which reveal that all applications in this matter concerning DNA shall be filed and responded to?
Yes.
Yeah?
Yes, my lord. Many applications which you directed us to exchange submissions on, and which we all did. I think on two occasions, the last time we were supposed to come before you to highlight these submissions, I think you were not sitting. And therefore we were deferred to today. But in terms of the applications that are pending, those are the only applications that are pending on which we have already submitted on. So the purposes, and we've also submitted upon them, in our papers. So for today, it was only an oral highlight, as you had previously directed.
So that application can be dealt with without prejudice to any application which may be brought by some.
Lord, I completely understand Senior Counsel's position having come in new, but previously you had directed that you don't want to delay the matter any further. We've been at it for the last 2 years now on this matter only. And we had wanted that it be resolved definitively now from the determination as you had previously ordered. I completely understand that you may have, the court may be, engaged, but we are in your hands in terms of if you want us to maybe get another slot. Or
so which one should come first?
So that was placed on record by one of the objectors. The will is a forgery, and the rest I had read out. So this was always raised. It's now just a question of which should go first. My Lord, in terms of what goes first, if an advocate sitting in this position believes that a colleague, for whatever reason, ought not to be there and ought to be disqualified, that's the first order of business. So, my good friend Mr. Kuyo, if an application is made that he is conflicted by reason of him or members of his law firm being potential witnesses or witnesses, then that is the first order of business. That must be dealt with first. I come in late, I know, but by coming in late with a fresh pair of eyes, and I'm the one who asked him why, and they said, well, it's been moving along slowly, and we were just hoping that we would get there one day. I think that's the first order of business. The second order of business is not who the beneficiaries are, but whether or not the basis upon which they came to court is a genuine or valid will. So if it is not a valid will, if it is a forgery, if it is otherwise not compliant with the law, then it's dealt with under the rules of intestacy. And that means we all go back to square one, and there is no dominant position by the petitioners, as they are currently constituted, sitting in the position of saying, we are the petitioners, you are the outsiders. There is no will, it's intestacy. They are moving under intestacy, and our clients are saying, we are also children of the deceased. So I believe that would be the second order. Then finally, of course, as I've probably said it already, then you deal with who are the beneficiaries. But I believe the question of the will, my learned friend used the word spanner in the works. I think, yes, as soon as there is a challenge to the will, there has been, and I've asked my learned friend to put in the application as soon as possible because he indicated that he would, then that should be the order of business. Now, my Lord, if we go the other way, as suggested by my learned friend, Mr. Kuyo, before you is the application as to whether or not DNA should be obtained in a couple of different ways. One is by way of the petitioners supplying their DNA to be matched against the objectors, and the other way, suggested by the young man with a beard, is that we should exhume the deceased and take a sample. While that might be the very last resort, we may not have reached there at all because we have living people who can be matched against. All I can say is that's the order. But of course, your Lordship is the judge of that. I think the best way perhaps is to have all the applications filed and give us another date for directions where you can have had time to consider which should go first. Perhaps even hear us more substantively when the applications are before you on which should go first.
On my part, I endorse the presentation by Senior Counsel Mugol that we need to address the issue of the address as a matter of priority In fact, when we were coming, I was actually ready to deal with the issue of DNA, but on reflecting and consulting widely, and also taking instructions from my client, who is with me in the court, Jacob is present. So we were ready, but upon getting instructions, I am for the view that we must deal with the issue of the will and the representation of, in the name of Procedural Honey. Thank you, Your Worship.
Heckling you. Tell them to stop heckling you. You know, I'm used to it. It's good to have a good-natured opponent. This is hard work.
Being filed, the applications challenging the will from the will I make this direction. All intended applications to be filed and served within 14 days. Any responses to those applications shall also be filed and served within 14 days of the receipt of the applications. Those applications which will be challenging the will from the will shall be had your motion in this case. That's where we are.
17th? Oh Lord, we'll take it.
When your clerk says so, we know it is final. We have tried to move her before. She does not move.
Unless my Lord will give us, will squeeze us in.
There is an statements as needed so that you don't avoid hearing of the 26th or 1st of July.
Yes.